Okay, our next panel is called The Art of the Deal, and I'd like to invite our two speakers, Doug Hand and Christopher Yu. Who are meeting for the first time. I'd like
very genuine interaction.
Very prepared, right?
Okay, I'm going to start by asking each of you, and I'll start with you, Doug, to talk about your business, your background, and how we got to the topic of the art of the deal.
Okay. I started at Sherman & Sterling in New York and for a year in the Paris office doing mergers and acquisitions work. I left with two other M&A lawyers to form my current firm, HBA, which focuses on the fashion industry, but transactional work in the fashion industry. We're on our 14th year. We have 25 lawyers, mainly focused on transactional work with a small IP department and a couple of litigators. I also serve as general counsel to Rag & Bone, a company for whom I've done a couple of transactions, Andrew Rosen investing at a very early stage in that brand, and Irving Place Capital, which is a private equity firm, investing a couple of years ago.
Well, I guess I'm the odd one out here because I'm here to speak from the client side. My name's Christopher Yu. I'm the owner and managing director of United Perfumes. As you can guess from the name of my company, between the four companies that I have, we design, manufacture, wholesale, retail, and PR, anything to do with smell. So if you smell anything nice, it's probably due to me. Anything bad, don't come and see me. So I lied. I'm a client side, but at the same time, I started my career as a tax lawyer for my sins back in New Zealand, as you can probably hear from my accent. And I was very lucky when I came to the UK to get fired and start my own company, which was completely nothing to do with the law and completely in the fragrance industry. My first role was looking after the UK for the niche French fragrance brand Diptyque. I was able to, very lucky, sell that in 2007, literally the week before the world changed. The market collapsed, and then started United Perfumes in a spare room. And through the recession have grown that now to 25 of us here in the UK. And what we do is, at the moment, for those of you who shop a lot, which hopefully in your industry you do, because we like to know that you buy our product, we distribute scented candles and fragrances throughout the world, but we also manufacture. Now, the most famous brands that we do have at the moment, and they're very independent, very small brands, Ceratrudon, which is the oldest wax manufacturer in the world since 1643, and we also have the license for Fornasetti, which is an Italian design movement from the 60s, which we create all of their scented home products for.
I wish I'd known you when I was at Kate Spade and our Estee Lauder license fell apart. And in those days, there were so few fragrance licensees to play with. So you're now in that category.
There's still not that many.
No, I know.
You know.
It's a small world.
Yeah. Le Labo just got bought as well. That would be another example of one.
Exactly.
Recently.
I think that it's
Estee
interesting,
bought
the
them.
title of The Art of the Deal. In the past sort of 9 months, pretty much 80% of the department store niche brands have been bought by two companies, and that is Lauder and L'Oreal. So it's an interesting time for us.
It's also true in the eyewear world, and lots of licensees. There are very few players anymore to choose from. Anyway, Doug, let's talk about, can you do a little case study on the Rag & Bone deal? To the
How about a hypothetical deal?
hypothetical? Okay.
Well, if the question is early stage company going through 2 rounds of investment and some of the issues that attend that, Mr. Rosen is probably not the best example of a non-fashion insider investor, nor is John Howard and Irving Place Capital, but there certainly is a clash of cultures that does happen when an early stage brand starts to consider taking on investment from what I'd call disciplined money, whether that's a venture capital firm or a private equity firm. You honestly have, a designer who may be riding in on a vintage Triumph motorcycle to offices in the meatpacking district with an arm sleeve of tattoos and wearing a t-shirt and ripped jeans, meeting with a group of 5 suited up lawyers and bankers, and they're trying to convince him or her or that design group that they're the right fit. Our money and our capability and background in this industry are going to help propel you and elevate you and escalate the brand. That can be difficult, but in my experience, and I think Andrew Rosen is a good example of this, it's important to be genuine as well. I mean, I think there are some investment groups that are very inauthentic in terms of how they approach those meetings. They'll actually try to show up looking like a designer, which is absurd. And designers, with their artistic background, I think they smell out disingenuous behavior. And obviously, if it's a partnership where you're coming in, you're taking a stake in the company, you're going to have some decision-making authority. There needs to be a level of trust beyond what the documents will ultimately say. So.
It's interesting you mentioned that, Doug. Through the sale of my first business right through to now, in fact, the last sort of 14 years, I've kept the same external legal counsel. Shout out to Paula Levitan. That wasn't a plug. She didn't pay me for that, by the way. And it's so much about that relationship and having that authenticity and having that genuine care for the client is priceless. And so when you're dealing with investors or any external party and having that relationship with your own legal counsel or even a good relationship with the other side's legal counsel is key to everything.
During the break, 2 or 3 young designers came up to me and asked, how do we get to that next step? Who do we know? Do we know who to trust? Should we go with private equity? Should we go with a public company? How do we shop our brand to money? Doug, what would you suggest?
Well, there are, very generally speaking, 3 sources of investment. The halo round that an early stage brand can take on is Uncle Albert and the guy that you were college roommate with, perhaps, a small network of people that know you and know the brand well. So just put a pin in that. And then venture capital and private equity, which we touched on, and then a more strategic type of serial investor, LVMH or Kering being good examples. There were more examples back in the day, like VF, that you had some experience with, or Jones. So it is about understanding what the goals of each of those investor classes is if you are the designer before you actually start to engage counsel to look at potential investors. Halo investors really have no agenda other than to help the brand. That's a pretty good mandate if you're taking in the money. However, it can be difficult. You wind up in situations. It can certainly be difficult. I'll speak to the lawyers here. Being in the position of, well, Uncle Albert wants to put money in. He's not engaging counsel. Can you just draft up something that's market down the middle? And you obviously have to advise Uncle Albert to get counsel and look at what you're going to prepare. That gets more and more complicated when the money seems to come in easily, and so people don't even bother papering it. So when you get to the stage where that discipline money is coming in, or potentially looking to come in, you wind up with a cap table that may have 3 names on it, and then there's an envelope that take a look at the back of this, and then there was a guy who helped us with our website, and we kind of promised to give him some equity kicker. It gets messy very quickly.
They do come out of the woodwork, believe me.
Yeah.
Any thoughts on that, Christopher?
Well, I hope I'm never in that situation, that's for sure. But I know who to call. Sorry, Paula. I think in terms of where to go to find, to sell your company to, is a want of a better description. It's like dating. I mean, you basically just have to find someone that has very similar goals to yours and has a similar lifestyle already. So for me, I'm always looking for people that have the infrastructure that I can plot my business into and basically benefit from. So it's basically matchmaking.
And that's always the challenge.
And some of the synergies have moved a bit. You know, whereas a decade ago, you could look at perhaps a strategic who had a vast real estate portfolio as being ideal. They're a private equity firm. They also have great real estate investments. We're a Coach. We're a Tory Burch. We're going to look to populate at least the U.S. with a bunch of stores. That may not be as appealing today. Maybe today you'd be looking at a company that has great IT and backbone experience and can help vertically integrate your brand. So, you know, that shifts as well on the strategic side.
Let's talk a little bit about clash of cultures. Having the many transactions I've been through have involved some tremendous clashes of culture between investors and designers, for example. Can you talk a little bit about that? Or investors and creative,
Yeah,
let me be more general.
I realize this is the, Luxury Law Summit and not TEDx, so I'm not going to go on about vulnerability and creativity, but I think so much of this comes down to being authentic on both sides. From a creative's point of view, I'm not a creative, I can't even draw a stick man, but I see with the creative team, a lot of the time, they just want you to understand why they're doing what they're doing. And funnily enough, from our legal team, they always want you, the creatives, to understand why they're doing what they're doing, and it's to protect them. So if you start from a point of understanding that we both want the same thing, then really it makes it so much easier. So it sometimes can be a little condescending in that sort of situation, but to really walk us through, you as the experts, as the lawyers, to walk us through why I need to know that now, why I need to worry about IP when I've just come up with the idea. I'm still stuck with my creative team thinking we've come up with the best idea since sliced bread. So for someone to say someone's going to copy you and someone's going to copy you in China, it's a little too far at this point. So to walk us back to the point of why we need to think about it and why we need to think about it now is so important.
Yeah, this really is cast in a stark relief when you're talking about eponymous brands, where someone has named the entire line after themselves. They've literally invested it with personal meaning, and there is an element of legacy to it as well, because if and when it gets sold, it will bear their family name. So they care a great deal about the story that is the brand, that is what sells the clothes or the accessories or the eyewear. Because let's face it, the goodwill that is attached to these garments is really the value that the discipline money is looking to invest in, or that the strategic partner is looking to help exploit. And when that gets wrapped up in a conversation about your name and your legacy, it really gets overly complicated. It gets very personalized and emotional. It's very hard for a pure investor, numbers-based person to necessarily see that. There, I think, is more risk in investing in eponymous brands than not, because of that very reason. Putting aside what I'll just call the John Galliano risk, right? I mean, you invest in someone's name and you don't necessarily know what that person does. But I think therein lies, part of the culture clash that can impact negotiation and valuation in a pretty material way. And it's only investors who do focus on it that can kind of understand that, and understand that recognizing the creative's directive is really the goose that they're buying that lays the golden eggs. If you stop and squelch that, you're just getting a commodity. And that's not what you're buying into at the multiples that the market expects you to buy into.
And even the most sophisticated designers don't understand that they really are selling their name when they're selling their name. And all you have to do is read the Joseph Abboud case, which is such a good example of the importance of really, really good drafting in a name and likeness agreement, both on behalf of the acquiring company, but also the person, the designer who's selling his or her name, who often gets so caught up in the joy of the money to come, and the joy of the money that will help build the brand to the next level, that they really don't realize what that really means in terms of selling their name, that it's gone. It really is gone. I mean, I've worked for designers who have come to me, sophisticated designers who have come to me and said, but I can do this and I can do this. And I say, well, look at the name and likeness agreement. No, you can't. You're taking the money and running. That's, you may be staying on at the company for decades, which would all be very well and good. But again, look at Joseph Abboud. He lasted,
Jill Sander, Dewey Chung, Simon Spur. I mean, it's a long
Yeah,
list. Helmut
it is.
Lang.
Yeah.
That's where a well-negotiated contract on the creative side will at least attempt to get a right of first offer, right of first refusal on the sale of the trademark, certainly in a case of dissolution.
Mm-hmm.
So the company has completely crapped out,
Yeah.
and it's just a fire sale. There are some bankruptcy implications on rights of first refusal, so there is that you have to deal with in the drafting. But obviously, the brand is worth more to the person that holds the name. So there is some gravitational pull, and it's no irony that Abboud is back with his company, back working for his company. I think he has an equity stake as well.
Yeah.
But you juxtapose that with the case of Jill Sander, who has, joined her company and left, and joined and left, and I think a third time joined and left. Obviously, from the investor's perspective, that's not what they wanted.
Yeah.
And, so notwithstanding that I represent brands and designers most of the time, I'm quite sympathetic to the other side of the argument, and I think that helps in a negotiation, because half of a negotiation is a dialogue with your client trying to, get them to meet in the middle.
Christopher, do you want to weigh in on that?
It's going to be the same problem for lifelong in terms of these sort of relationships where you have the creative and certainly in the situations where you have your own name. Again, I just come back to the fact of understanding the motivation behind who you're trying to negotiate with, and especially from the client side, the more, not necessarily sympathy, but the more understanding of the motivation. In this case, you've been talking a lot, Doug, about that it's their name out there, it's their reputation, it's their passion is very different. Helped a lot.
And once the investor comes in, that's not necessarily the end of the story. I mean, the designer may be very happy with the first investor, and then the first investor, obviously, if it's a private equity investor, is in it for the short run, maybe 5 years, maybe longer, maybe 3 years, maybe 2 years. And then there's another sale. And then one never knows what's going to happen to that company. So there have been brands that have had parent after parent after parent. And that is always the risk. And it makes you really admire people like Ralph Lauren who have managed to kind of hold on to their brand. Another Michael, as I understand it, Michael Kors has held on to his name through licensing, and
I believe that's
it's
right.
another option. How can good counsel solve a lot of these issues through drafting?
I'll take that.
Thank you.
I mean, I think certainly understanding the issues and perspectives on both sides helps with negotiation. In terms of drafting, the Abboud case certainly casts a highlight on the use of trademark and image rights, and really articulating that in what a layman would say is way too many words. But in the context of it actually, going to court would be, you'd be well advised to really articulate it. Making sure that the right of first offer or refusal with respect to the brand works and functions, whether it's in a normal setting or in a pre-bankruptcy setting, which can be slightly delicate. Then just tight drafting. I mean, it's an important document. The purchase agreement, or there aren't so many mergers in this space. They tend to be acquisitions or investments. But one thing I will point out is, unlike most M&A settings where the employment agreements are kind of an aside, certainly in this industry, because in the case with a designer who is core to the brand, that employment agreement and the non-compete obligations and other obligations that you put on them during their period that they work for the company, which hopefully is, as long as you own it as the investor, but even affirmative obligations after that period of time are also very important. In some cases, almost equally as important as a stock purchase agreement or asset purchase agreement.
I don't think I've ever been involved in a deal that hasn't involved the founder giving away equity, often verbally, often on the back of an envelope. How do you deal with that problem? And frequently lawsuits that result from that. When I was at Seven for All Mankind, after VF bought the company, somebody came out of the woodwork and brought, just, you know, of course it's always perfectly timed, you know, just on the eve of closing the deal.
Part of that is for all advisors, and at early stage companies, they usually don't have an investment bank that has shopped the company around and done diligence. So when we take on an engagement, there is usually subject to budget, it's always subject to budget, but diligence you do on the client so that those things come out of the woodwork and they can be tightened up, right? Documented in some way. That's why, you know, you tend to hate it when an early stage company asks, what's this going to cost? And it's...
We're always going to ask what it's going to cost.
Well, and, you know...
Just make you stick to it, too.
Right. Well, and you learn to estimate very well, but, you know, there can often be hair on the deal. And those unanticipated, you know, we didn't know that we were going to clean up your cap table and paper in that other 8% that three people hold. But you can handle that in an engagement letter, and, you know, I mean...
But it's interesting you raise that. Again, as a client, I mean, we're not going to talk about billing, but it is really important that you see this as a relationship for the long term. I mean, you can solve all of these problems if you have done every single round of deal with the same brand. So, you know, you won't have the clients, people coming out saying, I own 8% of this. But more importantly, when it comes to the due diligence, I will always forget. It's just one of those things. And so the more time you spend with me as the client, the more likely you're going to get the full story out of it. It's very seldom that we're trying to hide something. It's more, really, this is the last thing we have to want to think about, because we're trying to deal with the creatives or create ourselves. And so having legal counsel that's really understanding of how that fits in with what we're trying to achieve here, which is the sale of the business, and forming that relationship, I keep banging on about relationship, is really, really important.
Yeah, there's I think an inherent stickiness to the firm with the client post a transaction, assuming that it was not a sale of control, and, you know, your opposition now has a relationship with the acquirer. Rag & Bone is a good example of that. We were brought in to paper the initial investment that Andrew Rosen made, and then stayed with the company in a deepening capacity as they grew. When Irving Place Capital put their money in, we were extremely buttoned up at that point, and we as day-to-day counsel knew everything, knew where the skeletons were buried, and so in the diligence process could really streamline that.
You actually sat and still, I think, sit in their offices a certain number of days a week, so you really know their business.
One day a week. But yeah, I attend all board meetings, and my firm, focused on the industry, has a fairly unique outsourced general counsel function that we provide for a lot of clients, where it's a monthly flat fee for a 6-month period.
Now you're talking.
And it's essentially the basic blocking and tackling of what a GC would do. We're not going to go out and sue people for you. We're not going to acquire other companies for you. We probably won't do a big license for you. Those are all, you know, outside of the buffet.
There we go.
But the general buffet is open for business.
And that is not necessarily a new model. When I was at my fourth firm, where I stayed a year, was a small firm, smaller than yours, Doug, that actually was Hilfiger's general counsel. And they did the same thing, and they did most of their work. It was a very harmonious relationship based on a family, you know, kind of my cousin, the lawyer, but it worked out very, very well, and it kind of got Hilfiger from A to B.
That's interesting. We just represented his wife in the sale to one of your former clients. She sold her bag bar business to Kate Spade.
Oh, wow.
Yeah.
It's interesting. Well, thank you both very much. Anything you want to add before we quit?
The next panelist is fantastic.
Good. Thank you.